As professional employees, licensed attorneys generally don't receive overtime pay. But in Lola versus Skadden Arps, an attorney argued that his document review project required so little legal expertise that it didn't even count as legal work, entitling him to overtime pay. Skadden Arps was a law firm based in New York City. Skadden contracted with Tower Legal Staffing to provide attorneys on a contract basis to review documents in connection with pending federal multi-district litigation. Tower hired David Lola to conduct document review for Skadden in North Carolina. Lola was a North Carolina resident licensed to practice law in California. Tower employed Lola, but Skadden supervised his work. Lola examined documents for search terms provided by Skadden and separated documents containing those terms into categories that Skadden had specified. Skadden also provided protocols for Lola to redact portions of certain documents. Lola worked 45 to 55 hours a week and was paid $25 an hour. He was paid at the same rate for hours he worked in excess of 40 hours each week. Other contract attorneys working on the same project followed the same procedures provided by Skadden and were paid at the same rate for hours exceeding 40 per week. Lola sued Skadden and Tower, whom we'll collectively call Skadden, in federal district court. Lola alleged that Skadden had violated the Fair Labor Standards Act by failing to pay him overtime and sought to represent a class of similarly situated attorneys. The district court granted Skadden's motion to dismiss, concluding that, under North Carolina law, document review necessarily constitutes the practice of law. Therefore, Lola was exempt from the Act's overtime requirements because he was a licensed attorney engaged in practicing law. Lola appealed to the Second Circuit.